Okay, welcome back to another edition of Political Science Fun Time with me, your professor, Professor Dr. Selby. Today we're going to be talking about the Supreme Court. This is the first of two lectures on the Supreme Court. The next lecture is one of my more favorite lectures to give. This one's not quite as exciting because it's a lot of just description kind of and like, here's what's happening. Sometimes that's what we have to do in a course like this. The next one is a little more intellectually stimulating, which is quite enjoyable and fun. And where in the next one, I explain judicial review to you guys and sort of take you through some of the very basics of how judicial review works. But let's talk about first the origins of the Supreme Court in the United States Constitution. As you should remember from before, my federalism lecture, which was a while ago, but my federalism lecture, the Articles of Confederation were incredibly weak, and that was a problem. And when rewriting the United States Constitution, they increased the power of the central or federal government, including establishing a court system, which was not included in the Articles of Confederation. Now, judicial review itself, which has become the thing that we associate the Supreme Court with so much, is not clearly explicitly stated in the Constitution that that's what is expected of the court to do. Quite the opposite. It's sort of implied, but they don't break it out and say, Article 7, so the Supreme Court shall have judicial review. If you read the Federalist Papers, Hamilton, Madison, and Jay, they assumed, that judicial review was in there. But there's always problems with pointing to the Federalist Papers because there's only those three guys, right? And my suspicion here is that at the Constitutional Convention, some people were probably a little hesitant about giving judicial review to the Supreme Court. And so they probably kind of found this compromise language, which was a lot more ambiguous, but it was a political compromise to move the ball forward, so to speak. That's my feeling. Either way, judicial review is now established practice. Everyone expects it. It's 217 years of judicial review as of recording this video. So, there you go. The first, we would call that an implied power, right? It's implied in the Constitution that you're allowed to do this, but it's not explicitly stated. The Supreme Court sort of really formally gave itself the power of judicial review in the very famous Marbury versus Madison case. Now, I'm not going to get into the details of Marbury versus Madison because it's too nuanced and annoying to really want to do that. The Chief Justice John Marshall at the time, the vast majority of that ruling is actually concerned with articulating the logic of judicial review and showing that, in fact, it is implied and that it's appropriate for the Supreme Court to review laws. Okay, so they'd actually reviewed laws before this, but they had always upheld the laws. That means let the laws stand. They thought the laws were fine. In this case, they did overturn a law that was very controversial. And so justifying the right and power of overturning a law was pretty important to them. And so it's actually quite an elegant opinion. We're not going to spend any time actually reading court opinions. They're incredibly long, difficult to read, sometimes impenetrable. I do have an activity for you as part of judicial interpretation to kind of see some of the ins and outs of it. And that's a really fun activity that we'll be doing together as a class over the next week. Okay. Now, what else? So even after Marbury v. Madison, the Supreme Court didn't actually overturn a lot of laws. They were not particularly active. For the first 100 years of history, they were distinctly one of the lesser of the three branches of government. perhaps not even properly speaking a branch. It might be fair to say that, they were, I don't know, leaves or something like that. I don't know. So let's return to judicial review just a little bit. What is it? It's the power to make a law disappear. Fundamentally, that's what it is. So if the Supreme Court decides that a law is unconstitutional or in contradiction with some other law, so it could just be two statutory laws, they can just make it go away. Bye, goodbye. Okay. So, but there's really two. It's not just the ability to make laws go away. They're also tasked with interpreting laws, especially where they're ambiguous. Okay. So this interpretive piece here is also part of judicial review, and that happens both constitutionally for constitutional principles and statutorily for just regular laws passed by Congress. And then something's ambiguous in there. People aren't really sure how the law is supposed to operate. A lot of that fixing gets left to the Supreme Court. So if sometimes we speak of these as kind of like holes or inconsistencies in the law, where there's a hole, something that's unclear, the Supreme Court steps in to clarify it. If they do rule on constitutionality of laws, a law that is good is upheld. Oh, look at the law being upheld. It's a beautiful, wonderful law. A law that is bad is overturned. Bam, you knock the law over. Okay, if a law is overturned, it's literally just taken off the books, just erased. The Supremacy Clause, again, remember, think back to federalism and their sort of first constitution unit. Supremacy Clause says that federal law trumps or is more important than state law. So you see here on this pyramid, you have constitutional law at the top. That's the most important. You're never allowed to violate constitutional law. Then you have federal statutory law. Then you have state constitutions, state law, and executive orders or administrative law. Okay. Now, executive orders, they're not actually below state law and state constitutions, but I couldn't find a way of describing this quite properly. So they're more kind of just outside of state constitutions and state law, because executive order applies only to the federal bureaucracy, which state laws have very little influence over, although some, like crimes, certain types of crimes and civil penalties can be applied to you. If you're a federal worker and you violate a state law, you still have to follow those state laws. Okay. Now, I had a student many years ago who actually was retired, and he was just going back to school kind of for fun. And he had helped argue a case in front of the Supreme Court. And he told me this funny joke that lawyers refer to the Supreme Court as the Supremes. Okay, so a little bit of American history. The Supremes was a great rhythm and blues band. You see them on the bottom left there, featuring Diana Ross, who later went solo and also acted in some movies. She was a huge celebrity in the 60s and 70s and 80s. And there she is on the left with her two pals. Lots of R&B hits, from the Supremes. And then there's the Supremes, which is the Supreme Court. See, it's kind of funny. It's like a lawyer thing. Like, a lot of lawyers would get this. So if you know a lawyer, the Supreme Court, they're dressed in robes, not quite as fancy. They have a lot of hit records too. They're called Decisions. And they're the top court in the land, just like the Supremes were the top band in the land for a really long time. Okay. So the Supremes is kind of a cute little joke. So let's just return to the Supremacy Clause just for a second. The Supremacy Clause clearly stipulates that federal law trumps state law. States may go beyond what federal law or the Constitution stipulate, but not below. So let me give you an example. Federal minimum wage is $7.25 an hour, but many states have set it higher. For example, in California, it's $12 an hour. Okay, so in most things, you're allowed to go beyond what the federal government has done, but you're almost never allowed to go below. There are some exceptions, but not a lot. Now, there are some other things carved out specifically by the Commerce Clause that are left exclusively to the federal government, and states really aren't supposed to do anything on these things. So, things that affect interstate commerce, right? Again, one of the things you'll see is, as we get towards the later part of the lecture, is the exact bounds of one of the places where Supreme Court has a lot of powers in settling the bounds of federalism, right? And the Commerce Clause, they call it the Elastic Clause. We're not going to talk about it too much in this class, but the Elastic Clause, because it's one of these things that you can trot out in order to justify federal intervention in state behavior, okay? So there's some really notorious uses of the Commerce Clause by the Supreme Court, okay? How it works, getting on the court. Interestingly, the size of the Supreme Court is not set in the Constitution. It only says you have to have a court. That means Congress just decides how many people are going to be on the court, and they pass a law saying, we'll have 9, we'll have 11. Originally it had 6, right? It was just how it went. So 9 on the court. Justices are appointed by the president and confirmed by the Senate, okay? All federal justices are appointed for life, not just on the Supreme Court. All the lower courts, the district and appellate courts as well, all those judges are appointed for life, okay? This was done intentionally to insulate them from the electoral connection that drives so much political behavior in democracies, right? So we want our elected representatives to be responsive to public opinion. We want the Supreme Court to factor it in, maybe, but we also want them to feel secure enough to be able to go against public opinion when it truly is a matter of principle, right? Constitution says you're not allowed to do it. Well, then don't do it. The Supreme Court isn't entirely insulated from public opinion. They read, they know people talk, etc. It's good they're not completely, unhinged from public opinion. We want them to have a little bit of that kind of sense, okay? But it's a much more informal way of doing things. How it works, judicial review. So the Supreme Court decides which cases it will take each year. This is called their docket, okay? What's on the docket, okay? And it's just basically like a to-do list of cases. Well, we're going to take 15 cases this year, and it goes 1, 2, 3, 4, right? And they turn down tons of cases. They turn down something like 9 out of every 10 cases that are requested to be appealed. In almost all instances, you have to go through the appeals process, but in occasional instances, you can, in occasional instances like conflicts between government and stuff like that, the Supreme Court can kind of like jump in a little bit quicker. Just like school, they have a season. So it starts in the fall, just like school. They start in October, and then they finish in May and June when they start issuing their rulings, okay? So they decide which cases to take. They schedule hearings. Lawyers on both sides come and argue. They actually don't argue for very long. It's like an hour to 2 per side per case, right? So the oral hearings are surprisingly short, actually. They look at the evidence, okay? So evidence matters, the facts of the case law. They take briefs, and they meet privately to discuss their judgments, okay? The Chief Justice, currently it's Roberts, presides over the public meetings and the private discussions, and he also assigns cases to the other judges to write. This is all very important, right? Deciding who will write an opinion is quite important, and it's going to affect the final outcome. Justices, like everybody else, they kind of have pet issues that they really want to write about. And so sometimes they kind of really want to get things on the docket in order so that they can write the opinion, in order that they can craft the law on that subject. They also want to have a legacy. They want to go down in history as being a great justice, show their name for themselves, right? I get a little nervous about this element because it's like they're supposed to be legal people and they're not supposed to really care about their sort of larger historical reputation, but they really do. They care a lot about their larger historical reputation. And the court does sometimes solicit cases by saying effectively, we want to rule on X and we would like to take a case on it. And what that does is it stimulates other lawyers around the country to then go bring those cases. And, it's also not just prestigious to be on the court, but it's prestigious to argue in front of the court, right? That's a big deal for everybody involved. Now, the truth is, most cases are very technical, but the big ones aren't, okay? So, or they're technical and also political, depending on the big cases. So, most of them are really detail-oriented, or what we would say is pedantic, really small, nuanced, annoying pieces of legal trouble that the Supreme Court needs to sort of iron out. But many of the cases they take strike at some of the most fundamental issues that our society is facing, right? And pretty much everything at some point comes before the court. Most of the technical cases are decided with very little fanfare. They're 8-0, 9-1, 9-0, 8-1, 7-2, like very straightforward. But more political cases are almost always decided by a bare majority, 5-4. Okay. Okay. Now, the power to overturn a law, they don't pass laws, they only nullify laws. But that's still such a huge rule-making effect, okay? So, the power to overturn is really also the power to make something, if you take one thing away, something else is there. It's the power to make that other thing be what's going to happen. So they can't just overturn anything or make anything happen, but it really is a large power with a huge legal and policy making effect, okay? For example, if segregation violates the United States Constitution, then the Supreme Court can effectively order schools to integrate, right? Now, there's not a law doing that. It's the Supreme Court saying the Constitution says you now have to do this, okay? If limits on political donations violate the United States, the U.S. Constitution, then the Supreme Court can effectively order the other branches of government to allow unlimited campaign donations. Citizens United, right? We saw that one already in the systems model and civil society lecture. Now that's sort of how it works. That's the function. Let's take a brief look at the history. As previously stated, Marbury v. Madison marks an important turn in the history of the Supreme Court. That's when the Supreme Court first became so important. This ruling established judicial review through interpreting the United States Constitution. John Marshall served as the Chief Justice at that point. The Taney Court, run by Chief Justice Taney, so named after Taney, made quite a number, a few important decisions. One being Dred Scott v. Sanford, 1857, that unintentionally helped to precipitate the Civil War. The Dred Scott decision sits in infamy because it's a case in which the Supreme Court became very political and did a very bad job at it. And what they held in that case was that any African American even if they had the right to vote, even if they had been born in a free state, all of that, they didn't have they didn't have standing in court. Standing means the court recognizes you as someone who can bring a case before it. A foreign person can't bring a case in court. Not all the time. Sometimes they can. They have some rights, but they can't bring the same amount of cases. So you have to have standing. But when they held that and they returned Dred Scott to the South, Dred Scott was a slave who'd been brought to the North and then sued for his freedom. When they did that, effectively they were saying African Americans aren't actually citizens. You don't have standing with which to bring a case before the court. That's, really, 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 that lives in infamy for a reason. But we also saw their role in the Cooley versus Board of Wardens ruling a little bit earlier in the 1850s, which is a really important ruling in the history of federalism. Remember, that established basically what we called layer cake federalism, with like one layer on top and then another layer underneath, and they are entirely distinct. Okay. After the Civil War, the court kind of retreated out of political life a little bit. The mistakes of Dred Scott kind of weighed heavily on them. So, they kept making decisions, but they stayed more into the realm of technicalities. And through most of the rest of the 19th century, restricted itself to a little more properly speaking judicial matters. But there is some important action that's happening here anyways, especially a little bit later. So, 1885, we're 20 years after the Civil War. But the legal history of corporate personhood that became part of the Citizens United ruling begins here, especially San Mateo County versus Southern Pacific Railroad, which is quite notorious of a ruling. It seems like one of the lawyers on one side pretty much just lied to the court and some things like that. And also they didn't check. I have a longer thing on this later. I'll talk about it later. But anyways, part of the history of corporate personhood, San Mateo County versus Southern Pacific Railroad. And then one of the other most infamous court cases is Plessy v. Ferguson, that upheld separate but equal laws in the South. That's segregation and Jim Crow laws. And at the time, interestingly, that wasn't an activist opinion. That was largely siding with the laws that were in place and with public opinion, especially in the South, where, that's what a lot of people wanted. But maybe in that case, overturning some of these Southern segregation things earlier might have been really helpful for the country. But they upheld separate but equal. That takes us through the 19th century. And immediately after Plessy v. Ferguson, the court becomes incredibly conservative, and again, not remembered super fondly in this case. And we call it the Lochner Court, or the Lochner era, because in 1903, very famous Lochner v. New York case, where the Supreme Court overturned, that is, they canceled a law passed by New York State saying maximum workday of 12 hours. Now, you might be saying to yourself, I thought we had a maximum workday of 8 hours. And the answer is, yes, we do now. But before you start passing laws saying, look, maximum workday is this or that, people can end up working for really, really long periods. And Lochner ran a bakery in New York. He wanted his guys to work 16-hour days. They were effectively working 60-hour days. 16-hour days. When the case was passed, he was mad. He filed an appeal. It went to the Supreme Court. And he said, look, under freedom of contract, which isn't particularly in the Supreme Court, in the Constitution, but this court had a very sort of economic interpretation of the Constitution that enshrined some kind of almost libertarian sort of way of thinking. Freedom of contract. So they overturned the New York law. And even today, people talk about Lochnerism as judicial activism that's gone too far, right? They had a very particular way of viewing the Constitution that people don't view it like that anymore. And they were activists in overturning a lot of progressive era and then New Deal laws and legislation. Okay. Let's see. And they were a bane in the side, a thorn in the side of FDR. They overturned all kinds of New Deal legislation through the sort of 1830s. So FDR is elected in 1832, and one of the things that they used, one of the doctrines they used to overturn a lot of this New Deal stuff was what was called the non-delegation doctrine. The non-delegation doctrine is this: Congress is tasked with doing certain things. Congress is supposed to blah, 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 blah. Okay. Now, what's happened in the evolution of American government, especially as economies have gotten bigger and there's more to do, is Congress has started delegating some of the day-to-day of those types of regulations and things to the executive branch. So Congress passes a law, establishes an agency, and says basically the Environmental Protection Agency is going to have the ability to make certain regulations relating to environment, because it's a little too nuanced for us to sit down and haggle over every little fish that ever happened, right? So we're going to give the general idea. We're going to pass a law establishing the agency. We're going to guide them, give them sort of principles that they're supposed to follow. But then the day-to-day operation of this, we want the executive branch to do it. Well, the Constitution doesn't say if you're allowed to delegate some of your powers to somebody else or not, right? And it's an interesting question. I mean, if you delegate writing your paper to a friend, you're cheating. That's plagiarism. You're not allowed to delegate your work in this class to somebody else. But if my wife's boss gives her something to do, he's delegating to her. And then if she gives it to someone beneath her, she's delegating to them. And she better check their work and make sure that it's going all well so that her boss is happy. There's accountability here, right? But that's perfectly legitimate. She manages the office. She tells people to do stuff. That's her job. She's supposed to delegate. That's good. So which of these two cases is it? Is it that the Constitution mandates that Congress absolutely does every single piece itself? Or is Congress just good enough to give directions, to continue with oversight, right? They always have oversight power. If they want to change their minds, they can always take it back. But is Congress allowed to delegate or not? Constitution doesn't say that. It's an open question, okay? So the non-delegation doctrine was one thing that was bothering FDR, but lots of other things they were just overturning, right? Lochner v. New York was not a non-delegation question. And in response is a very famous episode in court history. FDR threatened to pack the Supreme Court. He wanted Congress to pass a law to add one new Supreme Court justice for each one that was over the age of 70 and a half. Yeah, they're usually that old. The court today is actually relatively young because we've had a decent amount of turnover in the last 10, 15 years. So the court's relatively young today, with a couple of exceptions. And actually it's been quite a bit of turnover. I feel like the turnover is a little bit more than it was earlier. I feel like from GW through Obama and Trump, we've had like a pretty decent amount of turnover. I don't have the numbers on that though. And so, basically FDR was like, look, we'll expand the size of the court and we'll just put more people on there. Of course, the people he's going to put on are people who are going to agree with him, right? And in response to this plan, the Supreme Court basically, with sort of self-regulated, pulled back and stopped overturning so much New Deal legislation, okay? So Owen Roberts here was kind of the key player, and he kind of was just like, yeah, I think FDR has a good point, and started siding with the justices that had been voting to uphold a lot of these laws, and then all of a sudden, instead of a 5-4 loss, it's a 5-4 win. And most of this happened. The first case was Owen Roberts and West Coast Hotel company versus parish. With that move, the court became much more favorable to federal power. This really pushed forward cooperative federalism that we saw again in our federalism chapter from like 6 weeks ago. That takes us basically up to World War II. There's some, in my presidency lecture, you remember I talked about Japanese internment. That's the most interesting thing that happened at the Supreme Court during World War II, sort of the war powers question. So I'm not going to address that here. It's more of a presidency question. But the post-war court, very interesting. We have what happens in the post-war is we have a very sort of liberal activist court led by Chief Justice Earl Warren. We call it the Warren Court, right? So it's the Taney Court, Lochner Court. Lochner was not a justice, but named after the ruling, and then the Warren Court. And Chief Justice Earl Warren had actually been governor of California, and he was appointed to the Supreme Court and spent 15 years as the Chief Justice. The Warren Court from 1953 to 1969 is also noted for its judicial activism, but in this case from a more liberal direction. Many of the cases people still complain about today or like today come from this Warren period of the court, okay? What are some of these big famous cases? Brown versus Board of Education, 1954. To Earl Warren's credit, wait. I do believe it was a unanimous decision. Yeah, it was. It was well, let me check.